Welcome back to the Constitutional Clarion. This video is in response to viewer requests. One viewer asked about whether the distribution of powers in the Australian Constitution could be affected by the Commonwealth government entering into treaties. And another viewer asked whether the Commonwealth could effectively buy legislative power by entering into bilateral treaties on domestic Australian subjects in exchange for other benefits. In this video, I'll address those two issues, but first of all, it helps to understand a little of the history about treaty making and how it works in practice so that you can then understand how we got to today's position. First, treaties are entered into by sovereign nations as an exercise of executive power. Prior to Federation, the Australian colonies had no treaty-making powers. Treaties were made by Britain for its empire, including its colonies, although it did allow some of its colonies to decide whether to participate in certain commercial treaties. There were also lesser agreements on matters like postal and telegraph communications that could be made at the colonial level, but they weren't real treaties. The Australian colonies could also not make any law that conflicted with Britain's treaty obligations. Any such bill had to be reserved for the monarch's assent, and assent would not be given. When the Commonwealth Constitution was being drafted, the framers, who were influenced by the United States Constitution, provided in the 1891 draft for treaties to be self-executing. That meant that a treaty once entered into becomes a binding part of domestic law without the need for any legislative action. As the Australian colonies were already unable to legislate in a manner that was inconsistent with British treaty obligations, you can see why they thought this was actually a small step to make. The British, however, strongly objected. First, it was contrary to the British dualist system, where entering into a treaty binds the country at international law, but has no domestic legal effect unless it's implemented domestically by legislation enacted by Parliament. But second, the British thought that this meant that the Australians intended to enter into treaties themselves, which was a shocking idea. One Whitehall civil servant exclaimed, "Well, they might as well be independent." Shock horror. The British also objected to the terms of the Commonwealth legislative power with respect to, quote, external affairs and treaties, unquote. They were worried that the Commonwealth Parliament would use this to confer a power on the Commonwealth executive to enter into treaties. Now, with all these objections, the British decided it was not very tactful to raise them themselves, so what they did was they lobbied George Reid, who was the Premier of New South Wales, and got him to ensure the removal of these provisions about treaties being self-executing and the words "and treaties" as attached to the external affairs power. Reid did so, and they were removed. Now, Federation involved 6 Australian colonies coming together to create a federation which was one big colony. Most Australians think that we became an independent nation with Federation in 1901, but that's just not true. The Commonwealth of Australia remained a colony and still could not enter into treaties in its own right at that time. The power to enter into treaties remained an executive power that was exercised by the monarch on the advice of British ministers. After World War I, this changed. The Dominions, as they had come to be known, sought greater independence, including in relation to foreign policy, diplomatic representation, and treaties. In the 1920s, at successive imperial conferences, Britain recognised the equality of status of its dominions, including their power to enter into treaties in their own right. The international community also came to recognise the status of countries such as Canada, Australia and New Zealand as sovereign nations which could engage in international affairs and treaty making. Now, this happened without any change to the Commonwealth Constitution. The existing Section 61 of the Constitution, which confers executive power, remained the same, but the scope of that executive power expanded to accommodate the power to enter into treaties. Implementing treaties, however, still required the enactment of legislation. This could be Commonwealth legislation, enacted under the External Affairs power in Section 5129, or state legislation. Or you could choose just not to legislate at all, but to not breach the treaty obligations. Because treaties often affect state laws, there is a Treaties Council and a Standing Committee on Treaties through which states and territories are consulted before treaties are made, so that the potential impact of a proposed treaty is recognised and an agreement can be reached as to how effect should be given to treaty obligations once a treaty is entered into. At the federal level, there's also a Parliamentary Joint Standing Committee on Treaties, which scrutinises proposed treaties before Australia ratifies them, and the Commonwealth is also required to present to that committee its national interest analysis, which explains the proposed costs and benefits of entering into the treaty. This all came about as a consequence of a parliamentary committee report called Trickle Treaty, which I actually wrote back when I was the Secretary of the Senate Legal and Constitutional Committee in 1995, a long time ago now. But back to the External Affairs power, why is it called that and what does it cover? The term external affairs was used rather than foreign affairs because the framers wanted to include within its scope relations with the rest of the empire, which was external to Australia, but not foreign. So that explains the rather peculiar terminology. The external affairs power has two aspects. First, it covers what's called geographical externality. Under this limb, the Commonwealth Parliament can make laws with respect to relations with other foreign countries or actions that occur outside Australia or things that are physically outside Australia. This may include, for example, making criminal the conduct of Australians or permanent Australian residents that occurs outside Australia, such as war crimes or terrorist training or child sexual abuse. It can also make laws about offshore mining or imposing sanctions on other countries. The second aspect of the external affairs power is the fulfilment of international obligations, such as treaty obligations. But what if the effect is to control matters that are within Australia rather than external to it? This issue first arose in 1936 in a case before the High Court called the Crown against Burgess ex parte Henry. Henry Goyer Henry was a maverick pilot known as the Pirate of the Skies. Now, this was partly because he had only one leg, having lost the other in a plane crash at Manly, but also because of his attitude to officialdom, which was symbolised by the skull and crossbones on the tail of his plane. Now, when Henry was prosecuted for not having a licence at the Commonwealth level, he made his two-fingered gesture to the government by rather spectacularly flying under the newly built Sydney Harbour Bridge. He was the first person to do that. He also went to the High Court to challenge the validity of the Commonwealth's legislation regarding aviation. The Commonwealth argued that its air transport regulations gave effect to a treaty and therefore fell under the external affairs power. Henry argued that the regulation of air transport within Australia was a domestic issue, not an external affair, and that the Commonwealth therefore had no legislative power to enact the law and the regulations under it. The High Court held that even if the external affairs power did apply, the regulations were not drafted in such a way as to give effect to the terms of the treaty. They were therefore invalid. But as for the argument about whether the external affairs power can be used to make laws about domestic matters if implementing a treaty obligation, the views of the judges were mixed. Chief Justice Latham was concerned about how hard it would be to characterise treaties as being international or domestic in nature. Justices Evatt and McTiernan took a very broad view of the external affairs power, concluding that the fact that an international convention is made about a subject necessarily brings it within the field of international relations. Justice Dixon, on the other hand, thought it was an extreme view that a treaty could be used to give the Commonwealth power over purely internal matters, and that the external affairs power should relate to matters which are, quote, indisputably international in character, unquote. Justice Stark thought that the power only extends to matters of, quote, sufficient international significance, unquote, to make them legitimate subjects of international cooperation and agreement. The issue was left unresolved and did not emerge again until the Koowarta case in 1982. The case involved an argument that the Commonwealth's Racial Discrimination Act 1975, which is intended to give effect to the Convention on the Elimination of All Forms of Racial Discrimination, was invalid because it deals with internal conduct within Australia, not external affairs. Now, in this case, the court split 3-3-1. Justices Mason, Murphy and Brennan considered that Section 5129, the external affairs power, authorises legislation which implements any bona fide treaty, regardless of whether the law applies to internal or external matters. Chief Justice Gibbs, Justices Aiken and Wilson picked up Justice Dixon's test from Henry's case that the subject matter of the treaty must be indisputably international in character to support legislation enacted under the external affairs power. In between, the 3 on one side and the 3 on the other, you have Justice Stephen. Now, he adopted an intermediate position holding that the subject matter of the treaty must be of, quote, international concern, unquote. But he upheld the validity of the Racial Discrimination Act on the basis that racial discrimination is a subject matter of international concern. So the court was divided with no clear majority. The issue came to a head in the Tasmanian Dam case in 1983. The case started when the Tasmanian Labor government wished to build a dam to support hydroelectricity production in the state. A state referendum, or more technically a plebiscite, was held about where to build the dam. The referendum result was in favour of damming the Franklin River, although many protested, writing "no dams" on the ballot. And in fact, you can still see the famous "no dams" sign as far away as Balmain in Sydney. The Fraser Coalition government at the Commonwealth level opposed the building of the dam. It tried to bribe the Tasmanians with money to build a coal-fired power station instead of its clean hydroelectricity station. But Tasmania refused. Fraser, respecting the federal system, refused then to legislate to try and override the state. But in the 1983 federal election campaign, the Hawke Labor opposition campaigned on a policy of preventing the dam. Now, by that stage, the Tasmanian Labor government had fallen because there were divisions within the government over whether or not to build the dam, and was replaced by the Liberal Grey government, which was elected with an even greater determination to build the dam. After Labor won the federal election, it enacted legislation purportedly supported by a range of different constitutional powers, including the external affairs power, to prevent the building of the dam. The area in which the dam was being built had previously been given World Heritage status, so the Commonwealth legislation relied on the implementation of the World Heritage Convention under the external affairs power to support the law prohibiting the building of the dam. The question was whether a law preventing the building of a dam in Tasmania, which is essentially an internal Australian matter, could be supported by a power to make laws with respect to external affairs. Although it was only 1 year after the Koowarta case, there had been a significant change in the composition of the High Court. Justice Aiken had died and Justice Stephen had left to become Governor-General. They were replaced by Justices Dean and Dawson. This time round, there was a clear 4-3 majority on the High Court. Chief Justice Gibbs and Justices Wilson and Dawson were now in the minority. They picked up Justice Stephen's international concern argument as a way of following the precedent from Koowarta. Chief Justice Gibbs stressed that no, quote, single power of the Constitution should be construed in such a way as to give the Commonwealth Parliament a universal power of legislation which would render absurd the assignment of particular, carefully defined powers to that Parliament, unquote. He considered that relations with other countries were not likely to be significantly affected by the building of a dam. The majority, Justices Mason, Murphy, Brennan and Dean, considered that the international concern test that had been used by Justice Stephen in Koowarta was too uncertain. They took the broader view that the external affairs power supported the implementation of any treaty as long as it was made bona fide, that is, in good faith. Justice Mason said that the international concern test was not clear. It's difficult to say of any treaty that its provisions will not benefit other contracting parties. If a topic becomes the subject of international cooperation or a convention, he thought it's necessarily international in character. Contracting parties have made the judgment that they will derive a benefit from it. He concluded that there was an absence of any acceptable criteria or guidelines by which the court can determine international character. The existence of international character is established by entry by Australia into the treaty. He considered that it was an invidious task for a court to make such judgments. It's a matter for the executive to enter into a treaty and for Parliament to give effect to it. Essentially, the court just didn't want to take up the highly political role of making judgments about the nature of different treaties and the validity of all Commonwealth laws that rely on treaties under the external affairs power, especially when there was no clear criteria that could be relied on. Now, this was the seminal case, and the High Court has followed it ever since. But it has nonetheless recognised 4 limits on the external affairs power. First, Section 5129 is subject to this Constitution, unquote, as all Section 51 powers are. And that therefore means it's subject to express or implied limitations in the Constitution. Second, the treaty must be bona fide. It must be made in good faith. It therefore cannot be manufactured just for the purpose of gaining power. Third, the law must actually implement, in whole or in part, the treaty. Just because there's a treaty about drugs, for example, does not mean that the Commonwealth can make any law it likes about drugs. When dealing with treaties, the external affairs power is treated as a purposive power, meaning it's directed at the purpose of implementing the obligations in the treaty. The law must therefore, and this is the test, be capable of being reasonably considered as appropriate and adapted to achieving the implementation of the treaty. Fourth, the law must implement treaty obligations that have a reasonable level of specificity. Mere aspirations, which give no direction as to how they are to be fulfilled, cannot support a law under Section 5129. the external affairs power. Now, this last restriction comes from a 1996 case called Victoria and the Commonwealth, sometimes known as the Industrial Relations case. It concerned Commonwealth industrial relations provisions that it was claimed implemented obligations in a number of ILO treaties. While the majority supported the broad reading of the external affairs power from the Tasmanian Dam case, it concluded that some treaties do not enliven the legislative power because they are too vague and aspirational in nature. It's not sufficient that the law prescribes one of a variety of means that might be thought appropriate and adapted to achieve an ideal. The law must prescribe a regime that the treaty has itself defined with sufficient specificity to direct the general course to be taken by the signatory states. The court struck down provisions in that case about harsh, unjust and unreasonable termination of employment because they were broader than required by the terms of the treaty itself. Partial implementation of a treaty can be sufficient. You don't have to implement every single provision of a treaty, but the law will not be valid if it is so selective as to deny the law the character of a law implementing the treaty, or where it is substantially inconsistent with the treaty as a whole. So in answer to the questions asked, yes, the executive can, by ratifying a treaty, expand the scope of Commonwealth legislative power, but only to the extent that the Commonwealth is actually implementing specific obligations in the treaty. And no, the Commonwealth cannot induce another country to enter a treaty with Australia about an Australian domestic matter and then use the external affairs power to enact a law implementing the treaty. And that is because the treaty would not be regarded as bona fide. Having said that, we actually have no authority on how a court would make that assessment of whether or not a treaty is bona fide. It really was a kind of warning shot across the bows of the Commonwealth, which quite wisely the Commonwealth has decided not to provoke the court about. So the issue has never gone any further and we don't have any precedents on it. I hope this gives you a good general overview of the external affairs power and how it operates. There is, of course, plenty more to say, but this video is already far too long. So thank you for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.